And I see some justification for this case consuming FYP's valuable airtime. So this is a case that you put in here, you people have put in here from the 11th Circuit Court of Appeals. And I read it over. While I was driving back today, for 6 hours, I was reading this. And I see some justification for this case consuming FYP's valuable airtime. The issue is a habeas corpus. Now, how's that so far?
So far, so good, so keep going.
The name of the case is Louis Matthew Clements versus Secretary of the Department of Corrections. And in 2008, Clements pled guilty to a single count of lewd and lascivious conduct in violation of Florida statutes. He was sentenced to 5 years of PFR probation. No time, just PFR probation. The terms of which provided that he qualified and shall register with the Florida Department of Law Enforcement as a PFR pursuant to Florida Statute 943.0435.
Do we need to describe PFR probation a little bit?
We probably should, because if it's Florida, it's going to be worser than anywhere else.
PFR probation is much stricter than any other form of community supervision. It involves frequent home visits, so-called treatment that involves the use of polygraph examinations, strict curfews, and really strict travel restrictions, except for Houston County, Georgia.
In 2017, roughly 4 years after the expiration of his probation term, Clements proceeded pro se, filed his first 2254 petition in the United States District Court of Middle District of Florida, challenging his conviction on various grounds. The district court dismissed the petition for lack of jurisdiction, concluding that Clements' obligation to comply with Florida's registration and reporting requirements for PFRs did not place him in custody for habeas purposes.
And on appeal, the Court of Appeals affirmed the district judge, holding with some hesitation that the restrictions on freedom of his movement imposed by Florida's lifetime registration and reporting requirements were not severe enough to place PFRs in custody under 2254, which is a federal law that limits habeas to review of state convictions to those who are in custody. And that was reported as Clements versus Florida, and that's Clements 1, 59 Federal 4th at 1204 to 1215, 11th Circuit.